Hello viewers and welcome back to this segment. We're second year LOB students at the prestigious International Africa University, and today we'll be looking at law of evidence. Our lecturer is Mr. MAPHOSA, and we're going to start introducing ourselves.
I am LOVEMORE, MUTASA.
And my name is Mushuma, and I'll be looking at contradictions and discrepancies within witness testimony, the cautionary rule, and I'll also be looking at corroboration of evidence.
And I'm Shamiso, and I'll be looking at evaluation of evidence.
Alright, and I'm Leopold MUTERO. I'll look at identification, both visual and voice, circumstantial evidence, demeanor.
And I'm DHAYIMANI. I'll be looking at presumption.
Okay, so we're done introducing ourselves, and we're now going to start the presentation. So I'm now looking at evaluation of evidence. So let's define evaluation. Evaluation of evidence. The evaluation process occurs at the end of a trial. Once all relevant evidence has been admitted, the court must assess the probative weight of the evidence to determine if it meets the required standard of proof. The evaluation process is done in the three steps: evaluating the evidence by itself in the context of all other evidence, and then measuring the totality of evidence against the standard of proof. A systematic and logic evaluation process must be followed on the following, based on common sense, logic, and experience. Principles and factors of evaluating evidence. Firstly, we have factual basis, witness credibility, cautionary rule, and weight of direct evidence, probative value, corroborating or confession, interferences from circumstantial evidence, and probabilities and improbabilities. Then, we're now looking at the process of evaluation. The first step is establishing a factual basis, resolving a dispute fact, and identifying a dispute of a fact. General principles for the evaluation process include the following: credibility and inherent probabilities, and nine-piece reasoning. So the first step, I'm now explaining the first step of evaluating evidence, establishing a factual basis. The first step is to establish a factual basis for evaluation. This involves analyzing the facts that have been proved by evidence, the facts that are not supported by the evidence, the agreed upon facts, and how the facts fit together to form a complete picture. The second step is identifying a dispute of fact. So how do you define a dispute of fact? A dispute of fact is a disagreement between the parties regarding a material allegation that makes up an essential element of a claim or defense. And proving allegations, the parties must try to prove the allegations through evidence and other probative material. Evidence in support of an allegation is not yet proof. Then the third step is resolving a dispute of fact. How do you define a dispute of fact? To resolve a dispute of fact, the court isolates the different questions of facts and the law that need to be determined. Then evaluating the evidence. The court evaluates the evidence and other probative material to determine if it is credible or reliable, and if it proves or disapproves the propositions of the facts. Then weighing the totality of facts. The court weighs up the totality of proved facts supporting each material allegation to determine if they are sufficient to discharge the honors of proof. Considering probabilities. The court evaluates the evidence to determine if it supports the plaintiff's or state's version, and if the accused and defendant's version is more probable. So we're now moving on to contradictions and discrepancies.
And when it comes to law of evidence, contradictions can arise in two ways, and that's internal inconsistency and external inconsistency. And internal inconsistency occurs when a witness provides contradictory versions of evidence, while external inconsistency happens when multiple other witnesses provide that contradicting evidence which contradicts the evidence of the first witness. So you have one witness, they say one thing, and then you've got two other witnesses or three other witnesses, they say something different from their first witness. That's external inconsistency. And then you've got importance of consistency. So consistency within a witness's testimony, its importance is that it impacts the credibility of the testimony. So self-contradiction significantly affects the credibility of a witness, making the evidence less reliable. Because with self-contradiction, you're going against yourself. So that basically means you're lying. It means you lied to someone, and that impacts the credibility greatly. And then another importance of consistency is that lack of consistency casts doubt on their testimony, and minor discrepancies in evidence don't cast doubt, but contradictory testimony can be fatal to the prosecution's case. And then evaluating witnesses. The importance of consistency is shown when it comes to evaluating witnesses, because if the testimony of the witness is consistent, then that means the witness is probably credible. So courts must carefully evaluate the evidence of both witnesses, avoiding the dismissal of a good witness due to contradictions from indifferent witnesses. And then I'll move on to my second topic, which is the cautionary rule. And the cautionary rule serves as a safeguard against unreliable evidence. It guides courts to be cautious while relying on potentially suspect evidence. And one way to comply with this rule is through corroboration, which provides independent support to be submitted evidence. And with the application of the cautionary rule, so you've got participants' evidence. And the cautionary rule applies to evidence that's provided by participants in the crime, such as accomplices, who may have motives to falsely incriminate others. So yeah, you have to use the cautionary rule, because if you steal and you have accomplices, those people know how the theft occurred, so they have greater knowledge to twist the facts of the case in their favor, so that they may be let off free whilst they put someone else under the bus. And then you've got requirements for application, and the rule considers the motive of the participant and their inside knowledge of the crime committed and how it was carried out, like I just stated before. And then you've got categories of suspicious evidence, and the courts must be attentive to certain categories of evidence, including accomplice testimony, co-accused statements, children's evidence, identification evidence, and evidence from complainants in sexual cases, because evidence from these groups of people are suspicious because they all have their own motives. And then we'll move on to corroboration. And corroboration is basically strengthening evidence. So what corroboration does is, it provides independent support to evidence that's already been offered in court. So corroborating evidence originating from a separate source strengthens the value of submitted evidence. And specific situations where corroborating evidence is needed are as follows. So evidence from accomplices, young children, and complainants in sexual cases often require corroboration due to their inherent susceptibilities, and focusing on accused implication. So in corroborating accomplice evidence, it is crucial to implicate the accused directly, ensuring the reliability of the accomplice as a witness. So what this means for corroborating, you've got reducing false incrimination, and corroborating evidence for other indications must reduce the risk of false incrimination before relying solely on accomplice testimony. And then you've got caution with child witnesses, and children's evidence should be approached with caution due to their developing minds, active imagination, and susceptibility to external influences. And then you've got weighing single witness evidence, and evaluating the credibility and reliability of a single credible witness is necessary before considering conviction solely based on their testimony. Okay, and then the importance of corroboration and caution. So in conclusion, corroboration and the cautionary rule are vital components of the law of evidence, and corroboration provides independent support, reinforcing the value of submitted evidence. The cautionary rule ensures caution is exercised before accepting uncorroborated evidence, especially when dealing with accomplices, children, and complainants in sexual cases.
Alright, so I'll pick it up from here. I'll be talking about the identification evidence in criminal cases. So identification evidence is crucial in criminal cases. Why? Because it is inaccurate, sometimes it is prone to error. So in this section, we will be exploring the different types of identification evidence, the challenges involved, the factors courts consider when they rely on such evidence. So we've got the visual identification evidence, we have the DNA and the fingerprints identification evidence, we also have got the voice identification evidence. These are all sorts of evidence. So I'll go on also now to talk about the circumstantial evidence in murder cases. So circumstantial evidence is like that missing puzzle, right? So what is it mean? It means the motive and the opportunity are examples of circumstantial evidence. It is often the main thing a judgment is based on a murder case. The court carefully considers the overall impact of all these conditions, as is said with circumstantial evidence, they are the missing link. The dead person has no voice, so the evidence becomes its voice. So judgment and reasonable doubt, once the court has considered the evidence, the accused is given the benefit of any reasonable doubt regarding whether the inference of guilt is the only reasonable inference that can be drawn. So from circumstantial evidence, we now look at the assessment of demeanor evidence. So what then is demeanor evidence? Demeanor evidence consists of everything that the fact finder can readily discern about a witness's performance. It excludes the semantics content of a testimony. So direct observation from witness demeanor. So assessment of demeanor requires a direct observation of the witness. And in this section, we discuss the court's assessment and how the witness demeanor collaborated the evidence presented, and how does it affect demeanor in the judgment. We discover the importance of demeanor evidence in criminal cases, how court assesses the impact of this evidence, and the effect it has on the judgment. So how someone carries themselves during the process of the court, how they look, how they are dressed, how their hair are, how shaved they are all part of their part of this evidence. So I'll then leave it up to Joseph. What then are presumptions?
Taking over you use of presumption. So what are the presumptions? Is it the best on the part Ben to prove his case from circumstantial, but what are them in the cases? Types of presumptions. In this case, we presumptions that is such as conclusive, refuting of presumptions.
All right, then we'll talk about the transcription evidence in criminal cases. So what then is descriptional evidence? Descriptional evidence is written record of something that was spoken. It can be used to corroborate a witness's testimony and prove someone's guilt or innocence in a criminal case. And we also have defense and an alibi. The defense presented a transcriptional of a telephone conversation that ultimately led to the dismissal of the applicant's defense of alibi. In this section, we'll delve into what happened and what it means for transcriptional evidence. And also, we are now looking at the errors. We are saying visual identification as evidence has got errors. So what are these factors that influence visual identification? So we talk of the lighting, we talk of the eyesight, we talk of the memory. These are all factors that can impact the accuracy of visual identification evidence. So in this column also, we can look at how each of them can affect the reliability of evidence, how dark the room was, how lightful it was. And we also now look at the court's role in preventing these errors. So the court must exercise caution when they rely on visual identification evidence, particularly if there is only one witness. By examining the circumstances carefully, the court can also prevent errors in the identification of the accused. So in conclusion, when evaluating evidence in criminal cases, identification of the accused in a criminal case is very crucial. But there are many challenges that the court can navigate. One way courts can do this is by examining all the circumstances carefully and considering all the factors that could impact the accuracy of the evidence. By doing so, courts can help prevent errors and ensure a just outcome. So, over to Lovemore.
I'm going to talk about the importance of establishing witness mendecity. Mendecity can be a witness evidence. Mendecity can make a witness evidence unreliable in legal proceedings. Courts usually rely on cross-examination to determine if a witness is lying or not. However, this approach has limitations. We explore other ways to establish witness mendecity and their impact on evidence presented.
Now we're looking at contradictions in witness testimonies and steps that can be taken to avoid this. So contradictions between statements of a witness and other evidence do not always indicate lying. Each contradiction must be carefully evaluated in terms of its nature, number, importance, and the impact on other parts of the evidence. Furthermore, contradictions between witnesses only indicate that one statement is incorrect, not the credibility of either witness. It is necessary to determine which witness is lying. So fact-based contradictions can exist between witnesses, statements, and proven facts, and contradictions with other witnesses. Two witnesses can testify to two different things, but it does not necessarily mean that one is lying. When contradictions in testimony over time, a witness may contradict themselves, but it may be innocent if it's a minor detail or explainable.
And the impact of witness mendacity on guilt. So proving mendacity does not prove guilt outright. Untruthfulness evidence alone cannot fill gaps in the case and establish guilt. The court needs to consider all the evidence and available information before arriving at a verdict. Even if an accused person is found to be lying or a witness's evidence is unreliable, it does not automatically prove the guilt of the accused.
Yeah, so looking at the contempt of court for failure to testify. So in civil proceedings, a witness who refuses to take an oath or answer questions may be held in contempt of court. In criminal proceedings, the court can inquire into their refusal, and if there is no just excuse, the witness may be sentenced to imprisonment for up to 2 years or up to 5 years for certain offenses. So refusal to cooperate, so a person required to give evidence who refuses to cooperate can be punished if there is no just excuse. And the right for legal representation. A trend follows allowing legal representation when a witness liability is at stake is emerging. So intolerable testimony also, we have a just excuse may exist when testifying would be humanly intolerable.
So judicial notice can be taken of certain facts that do not require proof through evidence and can be accepted by the court without question. And so we have a definition of judicial notice, and judges can take notice of facts that are common knowledge, notorious, or easily ascertainable. And two, what categories of judicial notice. And judicial notice can be taken of many different types of facts, including legal texts, easily ascertainable facts, and notoriety-based facts. And the scope of judicial notice, which is judicial notice can also be taken of the law. For convenience, saving time, trial costs, and preventing the admission of unnecessary evidence.
So categories of notorious facts. So first we are going to look at facts of general notoriety, well-known facts based on general knowledge, such as the number of days in a year, and facts of local notoriety, facts known to be reasonably informed people within the local area or jurisdiction of the court, and easily ascertainable facts, facts that may not be widely known but can be readily established through reliable sources such as maps and dictionaries. So we're going to hand this over to.
So now examples. So we need examples of judicial notices. So we've got four examples. The first one is words. So words, the meaning of words in legislation can be established using authoritative dictionaries. So dictionaries, what the word says in a dictionary can actually be an instance of judicial notice. And also the nature of animals. Courts can take notice of the instinctive behavior of domesticated animals and the potential danger of wild animals. We all know you can't stay with a lion. And we've got other issues like political matters, where the judicial notice can be taken of the existence of a state war, political systems, territorial waters, and constitutional development. So you can't be asked to prove that there is war in Russia. It's well known. So it can be taken as a judicial notice. And also maps and historical facts. Courts can take notice of historical or sociological factors from reliable reference textbooks. They can also lay maps and pictorial images for easy ascertainable or notorious information. So we can't be in court and say, is the world round? Where are the boundaries? These are certain facts that have already been accepted and can be taken as judicial notice. So lastly, we also look at the caveats of judicial notice. So judicial notice is considered prima facie proof. The parties cannot lead evidence in disputes these factors, but they can question on the credibility of the source. However, a party may appeal a court decision, its decision to take the judicial notice. So I hope you have enjoyed our presentation. So from me, Leopold, MUTERO, and my fellow colleagues, we hope you enjoyed, you learned something. The rest, you fill in the gaps, we know you will enjoy. Thank you very much. Bye-bye.